Good morning, Justice Vronska. My name is Ted Zazechny, and I am the Vice Chairman of the Selection Commission. I take the opportunity now to announce that Justice Ivan Mischenko, a colleague of yours on the Supreme Court, has recused himself from participation in this interview. First of all, Justice Vronska, I wish to welcome you to the Selection Commission process of interview. I much appreciate, as is the case with all candidates, your candidacy for membership in the High Qualification Commission of Judges of Ukraine, and I thank you for your participation. A few introductory remarks, Justice Vronska. As we know, there are some difficulties with communication currently in Ukraine because of the circumstances of the war. If we should happen to lose contact with you, please don't worry yourself or be disturbed. Our staff will reconnect with you as soon as possible, and if necessary, we will reschedule, but continue your interview from where we left off. Secondly, Judge Vronska, we will give you the opportunity at the beginning of the interview to provide us with some of your circumstances, and in particular, we are interested in hearing from you your motivation for your application as a member of the High Qualification Commission of Judges. Our process will involve your introduction by certain rapporteurs, and in this particular case, the members of our selection commission responsible primarily to take leadership in your interview will be Judge Verlanov and Stephen Markman, Justice Stephen Markman. So with those introductory comments, I am going to invite your opening comments to the Selection Commission. You will also have the opportunity at the end of the interview to also provide us with any further or other comments that you may have. So with that, I will turn the matter over to our rapporteur, Judge Verlanov. Oh, Stephen? Justice Stephen Markman. And Stephen, if you would please take the chair.
Thank you, Judge Zarzechny. And thank you, Judge Vronska, for your participation in our competition. Our candidate this morning has been a private practitioner of the law for many years. She's been a deputy minister of Ukraine, and since 2017, she's been a judge on the commercial court of the Supreme Court of Ukraine. We're very pleased to have you, and if you'd like to take advantage of your opportunity, you would have as much as 5 minutes to introduce yourself, and if you'd like to explain further your motivation for participating in this competition. Thank you again, Judge.
Good afternoon, dear colleagues of the Commission. Thank you, Mr. Rapporteur, for giving me the floor. I'm Hanna Vronska. I'm the judge of the Supreme Court. I grew up in Kyiv. I graduated from the Institute of International Relations in the field of international law. I've got diploma of the lawyer in international law, and I have a fluent command of English. I started working when I was a student, and after graduation from the institute, I started working in one of the best legal law firms of Ukraine, Vronska and Partners. I was lucky enough to work with the founder, Vronska Hanna. I used to be his assistant, and then I became their attorney at law. I had a lot of court cases, where I had to represent the interests even of international companies, foreign clients. After I worked for several years in the law firm Vronska Hanna Partners, I founded my own law firm where I was the director and the managing partner, and I've got 10 years of such experience. And after the Revolution of Dignity, I worked in civil service and I was appointed Deputy Minister of Ecology and Natural Resources of Ukraine, and I was responsible for the issues of European integrations and international relations. And this experience helped me to find out what public institutions work like and what the situation there is. I had to be responsible for the harmonization of Ukrainian legislation with acquis communautaire in the environmental aspect, environmental protection aspect. And as far as environmental law and environmental protection is concerned, you have to work in several different directions, important directions, because it's a complex issue. Then I was dismissed from this position, and in 2017, or actually in 2016, I applied for the competition to the Supreme Court, and now I've been the judge of the Supreme Court for 5 years. For 4 years, I was the secretary of one of the chambers on corporate disputes, and I've been combining my experience of managerial activity with this job because we made a lot of analysis and generalizations of the court practice, and we provided some methodological assistance to appellate courts. We organized a lot of joint meetings with researchers, with developers of draft laws in the field of corporate relationship since before the full-scale invasion. You know probably that we had the reform of corporate management, so that's my experience. As far as my own motivation for participation in this contest is concerned, I've indicated in the motivation letter that I passed the qualification assessment, and I know it from my own experience what the expectations set for this competition could be, and I understand that we have high demand in the society concerning transparent conditions of such selections. And this is one thing. And the second thing is that I would like to use my experience in the activity of the new HQCJ. It seems to me it is important that in the operation of the new HQCJ of Ukraine, there is the representative of the Court of Cassation instance. Because if you work in the cassation interest, in the cassation court, in cassation cases, probably you are more able to see some systemic mistakes, blunders, or not the weaknesses, but the strengths of the court practice. And it seems to me that this could also help me make a contribution into the operation of the new High Qualification Commission of Judges of Ukraine. And the most important thing is that my background, my experience could be helpful from the Supreme Court, because you know that some judges have started using new structure for laying down their decisions, and we can see that, judges of the Supreme Court, and we can now see that judges of trial courts are also trying to follow the structure introduced by the judges of the Supreme Court. And I think that the experience and the practice like that should be maintained, and you need to teach judges, to teach judicial candidates intending to become judges what this practice should be like. Thank you.
Thank you very much for your opening statement, Judge. Let me get one question out of the way very quickly, if I can. Is there anything that this commission should know about any legal relationships between yourself and members of your family with the Russian Federation at all, or Crimea?
Thank you for the question. I actually expected this question to be asked. I guess you are talking about my father, who is a biologist by profession, and since 1996 he was the head of one of the units of the Institute of Southern Seas, and then he was the director of the nature reserve in the Crimea. He's got his own private house. I have not been communicating with my father for a certain period of time, at least over the recent 3 years. I haven't seen him. That's what I can tell and what I can answer to your question.
I'm always sorry to have to inquire about
And
it.
by the way, sorry, I have some.
Go ahead, please.
Because I think that you are going to ask this question as well. Real estate, I have. It is also located in the Crimea. I bought it in 2001. Actually, it's about 240 square meters. This is some structure which was used as the warehousing facilities. And I neither actually nor legally, I don't have any data for the use of this construction. I have never been using it, and I have never given an issue of a power of attorney. But I keep declaring it because I still think that Crimea is Ukraine. And after victory, we will get clear with this property.
I was beginning to say we're always somewhat hesitant to ask about candidates' relations, but we do have the need for a transparent and open procedure, and sometimes we have to ask questions about those things. But thank you for your direct response. We appreciate it. Judge Vronska, you, of course, as you indicated, participated in the Supreme Court competition in 2016, and you were obviously quite successful in that competition. You're now participating in the selection of members of the High Qualifications Commission. And the first competition sought to select judges, and this competition seeks to select judge selectors. But they have many things in common. Can I ask you to compare and contrast your experiences in the first competition with what you have gone through thus far in this competition, and indicate what you see are the strengths and weaknesses, perhaps, of those competitions, and what must be done in the next competition conducted by the High Qualifications Commission to make sure that it does the best that it can do to elevate the judiciary of your country?
Well, thank you for the question. The competitions are really different. It seems to me that after the competition for the Supreme Court, nothing could have prevented me in my desire to go for any other competition. But I think that one of the important characteristics of the competition for the Supreme Court was the possibility provided to not only to the candidates who used to be judges. I mean that if we take this example of the Supreme Court, we have the synergy of different experiences of different backgrounds of the people who are now working there. These could be researchers who came from educational institutions, and they didn't have the judicial background, but they brought in their scientific background. Lawyers and attorneys at law, with their background, also developed a more adjusted practice of the Supreme Court, more adjusted to the reality of life. So it would be really good if this opportunity provided to non-judicial candidates to participate in the competitions would be preserved. It should be maintained, supported further on, and I would consider it one of the major principles, because we also need to support this approach and such candidates. It seems to me it's really important to have this synergy. It's important to have a merger or a combination of different experiences. This promotes effective hearing, case consideration, and I hope that the experience of the Supreme Court is a very good example of this. As far as the difference between the two procedures of competition for the Supreme Court and the HQCJ are concerned, well, they are similar because you have professional competence verification and you have to check integrity. Well, the procedure for the Supreme Court was more complicated and longer, I would say, and we actually had the expectation that it would be finished sooner, but actually it lasted more than a year. It seems to me that this experience also needs to be taken into account, and everybody says that the next selection procedure should be simplified. There are a lot of preconditions for such simplification. First of all, it's necessary to fill in the vacancies that we now have. It's necessary to introduce a transparent procedure to be well perceived by the society. And of course, there are also some technical issues that would also allow to simplify this procedure, and I think that then the result will come quicker and it will be better. And I could also say that the change of the procedure of selection of would-be judges is our commitment according to the commitments we have to the European Union because of the credit that we have got from them for 18 billion euros, because the violations of our commitments may have some financial liabilities for Ukraine.
Judge, what if I was to suggest to you that the process ought to be made less simple and more complicated by more aggressive qualification assessments, and that qualification assessments to a certain extent have been very superficial over time, and that they haven't resulted in the closest scrutiny of the work of judges who are sitting on the judicial branch of Ukraine? What would you say in response to my suggestion that we need more complexity? I'm not sure I favor that, but I'd like to hear your answer nonetheless.
Well, first of all, we should differentiate between the selection procedure, and when I was talking about our commitments and about simplified procedure, I didn't mean the qualification assessment, I meant the selection procedure of the would-be judges. And your question is related to qualification assessment, as I think, which is not an ideal procedure. But as a person who passed this qualification assessment arranged under the new methodology, it's difficult for me to say whether it can really be made more complicated, because the load during this procedure on the candidates was really high. We had to pass the test. That was the test confirming our professional skills and competence, our personal traits of character, our social competence, our professional ethics, and our integrity. And one of the components of this procedure was also psychological testing. Probably it was more difficult for us because we were the guinea pigs. We were the first to undergo this procedure. But anyway, I don't see any other chances for making this process more complicated. But if somebody has not passed the qualification assessment as yet because of the lack of time, whether they should follow the same procedure or the procedure should be changed, if I'm asked this question, again, maybe you were going to ask this question as well, but it seems to me that not to have any grounds to claim that there have been unequal terms, it's better to follow the same procedure for the judges who have not yet managed to take their qualification assessment. But I don't think it should be made more complicated, and I can't even think how it could be made more complicated.
Let me ask you one final question for the time being. Judge, you state in your motivation that currently Ukrainian society does not trust their judiciary. And it does seem as if there's considerable evidence in support of that proposition. Can I ask you if you were speaking to the people of Ukraine, and I think you are speaking to the people of Ukraine, what would you say to them about your elevation to the High Qualifications Commission? How will that, in your hopeful expectation, enhance their confidence and trust in the judiciary? What will they take away from our appointment of Hanna Vronska to the High Qualifications Commission? What should they know about you?
Shall I speak about myself or about my candidacy or about my vision?
Well, I think we're talking about all of those. If they learn that this commission has tried to reform the High Qualifications Commission by appointing new people to the commission, by having a new High Qualifications Commission, and one of those people will be Judge Hanna Vronska, what do you want the people to know why they should look upon that as news that this is going to be a different commission, a new, better, stronger commission, creating a new, better, stronger judiciary for your country?
Well, I don't know whether people should be happy about hearing that I become a member of the HQCJ, but they definitely have the right to know who I am. But all the information about me is available in my dossier, available on the website of the High Qualification Commission. And there are a lot of other public sources of information about me. And I think that after I passed the competition to the Supreme Court, there is no information about me that it is not in public access and is not available in my dossier. And I think that this is also my advantage as a candidate. As far as the general procedure is concerned, I would just be brief, but probably a little bit even arrogant. The more transparent and scrupulous the procedures of qualification assessment to be introduced by the HQCJ are, the more trust, the higher the level of trust the society in the judiciary is going to be. This trust cannot be established overnight, over 1 month or 1 year. This trust should take the evolutionary way, and I'm sure the development of this trust should be started with the procedures of selection of judges, for the society to really know how judges are selected, who these people, who these candidates are, what their background is, and what they can actually bring in terms of the experience that has allowed them to become judges. We have been saying it many a time that there is a difference in the level of trust between the people who participate in court hearings and the general public. We cannot say that these are just lawyers, and if we speak in general about the society, most people have never been to courts, have a very superficial idea of the activity of courts, but they don't trust courts. So we should work at the revival of this trust. And, well, I could talk for hours about that because this process includes a lot of components, but to be brief, well, I just cannot find any other word, but scrupulousness and transparency of selection procedures will become the precondition for revival of societal trust in the judiciary.
Thank you very much, Judge Vronska. I'm going to turn things over to my colleague and fellow rapporteur, Judge Sergei Verlanov.
Thank you, Stephen. Hanna, good afternoon. Good afternoon. So, to follow up with Stephen's question, I would like to ask you concerning revival of trust, societal trust in the judiciary. And let me ask you the following question. Why do you think that the implementation of your professional competences in the position of the member of the HQCJ will make a contribution in terms of revival of trust in the judiciary? And why is it going to be more important than the work of yours as the judge of the Supreme Court now? Well, thank you for the question. First of all, let me tell you that I've got some experience in the development of communications policy, in particular communications policies of public institutions. That's why we're talking about revival of trust in the judiciary. But in fact, it's difficult to reproach the judiciary and say that the judiciary is not willing to do anything about that. But for the judiciary in general and for courts to have their own policy, they should have this capacity to do this. I like the experience of the executive authorities when, every ministry had the offices of reform support, which were funded from the international financial aid, and they had people whom they recruited to those offices, and the offices assisted the ministries in the reform implementation, and they undertook a part of communication and advocacy policy work. I don't mean that we should create such an office for the High Qualification Commission, though I think it would be good. But of course, the mandate of the High Qualification Commission that we have under the legislation could not be performed by this office, but some technical issues could. Maybe judicial bodies sometimes don't have enough staff members to deal with communication policy, and you need to understand this. So they maybe are willing to do this, but they don't have the capacity. And if we combine those two components, we need to create the opportunity. And it seems to me that I know how to create this opportunity. Clear. Thank you, Anna. And here is the next question to you. Out of the materials we have, we can see that you're also a member of the supervisory board of the NGO, the Association of Women Lawyers of Ukraine, Eurofem. And this shows that you actually confess the principles of gender equality. Could you please explain what practical and specific mechanisms are most efficient for you, as you think, for the judiciary to follow the principle of gender equality, and how we could at the same time guarantee and ensure the principle of professional competence? And here is another question. What is your personal attitude to the mechanism of introduction of gender quotas? Well, thank you for the question. I've really been consistently supporting the principle of introduction of gender equality at all the levels of life, including at the level of political decision-making and in daily life communication. If I were asked what the previous HQCJ lacked, I would give a very simple answer. It has quite a good legislative methodological base. Well, probably the methodological base should have been updated, but it didn't have the strategy of gender equality. And so far, out of all the bodies, judicial bodies, only the state judicial administration has the strategy of gender equality in place. And it seems to me that every state, every public institution should have such a strategy in place. Maybe the HQCJ should be among the first bodies to really have this strategy, because it is responsible for the selection of would-be judges. And the strategy is not just some abstract concept or abstract statements and phrases let out in a nice format and in some presentation, in some document. The strategy should really presuppose some measures aimed at improving the culture of provision of equal rights to men and women. I could actually talk for long about this. Just stop me. Okay, it's clear. So far, we have almost the same number of men judges and women judges. But as far as court staff members are concerned, we have more women. But if we have a look at the statistics of top positions in the judiciary, of course, we have more men. So this is the general trend. The judiciary is not an exception here. But in order to cherish this culture of equal attitude, equal treatment, we need to start from the beginning, right from the beginning. I hope I've answered your question. And you asked the question about gender quotas. I am the supporter of gender quotas for political parties. I also support gender quotas for the supervisory bodies of corporations. It seems to me that this long period, this actually, this is not the best issue to discuss. I mean, this comparison between professional competence and gender equality, because over a long period of time, women have just been deprived of the chance to participate in political decision-making processes, deprived of the chance to generally build their career at the same level as men. Well, it's easy for me to speak English, but okay, I'm trying to pick words in Ukrainian. So, majorly, all the advantages were with men, and now we can actually equalize the situation level it up through quotas. So, I support gender quotas. Clear. Thank you. Stephen?
Thank you, Sergey. Our next questioner will be Prosecutor Burkhuizen.
A very former prosecutor and attorney now only. Ms. Vronska, listening to you, I'm wondering, here's the microphone, why someone who is in the Supreme Court, who is looking after the security, the unity and the consistency of the judicial practice, quite an important job, should be a selector of judges, because is it not so that there are much more people qualified to be a selector than that there are people qualified to be a Supreme Court judge?
Well, I would rather argue with you, but I just want the judiciary to have more judges that can really change the system for the better.
Okay, and so what you say is that if there are more...
I just hope that my experience could make a contribution in this.
Yeah, of course I understand that you hope that, but the question is, of course, if you want to make a contribution, is your contribution not also important in the Supreme Court? At least.
Yes.
Yeah. You say that, well, I want to make my contribution in hiring more staff. Is that hiring more judges the solution to all the problems?
No, I probably meant to say that it would be better if the judiciary didn't have the increased number of judges, but had more judges who could change the system for the better.
Okay, of course. And you have been a lawyer quite long, let's say attorney, not being a judge. Were you a litigation attorney?
Yes.
can you please tell us what was your experience with the judiciary and the courts in Ukraine when you were a lawyer?
От, власне, мій досвід роботи
My experience of working as a lawyer,
мене потім взяти участь у доборі
as an attorney at law, was the experience that urged me, incentivized me to participate in the competition for the Supreme Court. When I worked at one of the law firms, which was one of the best law firms back then, and we had a lot of clients, international foreign companies, that had to protect their interests in the courts of Ukraine. And back then, I came to realize how important it is to have a transparent, efficient, and fair judiciary, not just to protect the interests of specific citizens, of individuals, but to improve the investment climate in the country. And we all know perfectly well that the main obstacle on the way to investment, if we speak about the pre-war period, was the judiciary. Foreign investors were complaining majorly about taxes and about the judiciary.
в той час я усвідомила.
So then I just realized that the judiciary should be changed, and that's why I went to the Supreme Court to change the system. My motivation for the HQCJ would also be to change the judiciary, for the judiciary to get as many judges that could really change the system for the better.
Які також готові змінити систему, змінити практику.
You also been a deputy minister in the government between 2015 and 2016.
Так.
Right?
Why did you choose to be in such a position, which is a political position?
Дякую. Я
Well, thank you for the question. I also expected this question. I don't consider this position to be political. It was not a political position de jure or de facto. That was just a technical position. It was deputy minister on European integration. I had a very narrow direction to work within, to be responsible for or to coordinate the issues of adjustment and harmonization of the Ukrainian legislation with the EU legislation and EU directives. That was not a political position. We did not depend on any political parties, and I was not appointed to this position by any political party or upon the recommendation of any political party. Back then, after the Revolution of Dignity, that was quite a common practice that the government invited legal professionals with some experience of work who knew English to implement the reform. We were implementing the reform in the field of environmental protection. That's it.
Okay. But of course, in the end, you would have been appointed by politicians, wouldn't you? The reason I ask the question is, of course, is that people who look at you and look at, in any case I do, when I look at your biography, would think that you are someone who's well, let's say, involved in politics, or in any case knows a lot of politicians, because maybe it's wrong, but I would think that if you've been appointed as a deputy minister, you must have had friends in high places, because otherwise you would not have been appointed, because they would not have known you.
Я би відповіла так.
Well, let me give the following answer.
Скоріш за все, у вас уявлення
Most probably,
про
your
заступника міністра
idea about the position of deputy minister is based on the European reality.
ми мали трохи
in Ukraine, our situation was a little bit different, and for that period of time, that was just rather common practice to have professional lawyers appointed to governmental positions, and this did not testify to any political engagement. And it seems to me that in the current times, this doesn't have to be proven in Ukraine and Ukrainian citizens. And I've actually not faced such interpretation of my stay in this position because, a lot of my friends who are lawyers also held the same positions in other ministries. They were frustrated why I was not in the Ministry of Justice, just in the Ministry of Environmental Protection, but that was the case. So anyway, I have not been faced with this problem in this context, and it seems to me that Ukrainian citizens must understand that in that period, in that context, that was absolutely okay. Formally, I was appointed by the Cabinet of Ministers, not the Parliament.
Okay. But let me make my question then much more simple. And the question is, do you have political friends in high places?
Я б відповіла, я похилилася від відповіді.
I would rather evade the answer if I answered no. But I have. But these friends are the same lawyers who started holding those positions after the Revolution of Dignity. I mean, they are not professional politicians. But, right, I do have such friends. I used to have friends in the previous government and in the previous Verkhovna Rada, but now the composition of the government and the Verkhovna Rada have changed, and among those politicians, I don't have any friends.
And is the fact that you have friends who are lawyers, who are connected with politics, not a difficulty if you want to be appointed in the HQCJ?
I don't see any problem about that. That was the acceptable practice, common practice for Ukraine back then.
Okay. I will ask my friend Yevgeny what he thinks of this.
About political neutrality.
Yes.
Доброго дня, пані Анно. Моє прізвище Мізинцев.
Good afternoon, Anna. I'm Yevhen Mezentsev, and I'm going to ask you some questions.
Можливо, якоюсь мірою вас
Well,
потішити, оскільки
probably I would provide some good news to you because
питома вага
the share of women in our selection process,
у другому етапі
to be more specific, in the second stage, is even a little bit higher than the share among the
анкет.
documents, the candidates who submitted documents to us at the beginning, which means that we are following gender quotas and gender equality, even if it's not prescribed in our internal documents.
Пані Анно, стосовно
Ганна,
вас, очевидним є досить
it's obvious
вражаючий
that
юридичний бекграунд.
you have a very good legal background, great achievements,
Підтримка громадських
support from civil society organizations,
організацій юридичного толку.
recognition
І крім того,
by civil society organizations. And besides that, you are mentioned as the person who has started applying in her decisions the models and the templates that are used in the decisions of the European Court of Human Rights. You've been among the first people who have started doing this, which means that you are a professional and a very progressive person. You're not being afraid of being a leader and creating new conditions for the work of your colleagues. At the same time, my first question will refer to the approaches to assessment of incumbent judges and would-be judges. I mean, selection of the people who have got no judicial background. Currently, and this is, by the way, not the issue which has appeared out of nowhere, this is the result of one of the cases, discussion on one of the cases considered by the Grand Chamber. The point is that under current conditions, following the current rules of the HQCJ, there may be different approaches to assessment of incumbent judges. within qualification assessment and could be different in terms for the selection of judicial candidates who don't have any judicial background. And there is an opinion that this is a discriminatory approach, that these terms are different between, because this results, anyway, both procedures result in further holding of the judicial position. What do you think of this? Should we still have the same procedure of assessing incumbent judges and would-be judges, or should we leave two separate procedures which are different in terms of the essence, the core, and the approaches?
Дякую за запитання. По-перше, я хотіла
Thank you for the question. Well, first of all, let me tell you
при доборі суддів на
that
посади
when judges are selected to trial courts, as I understand the regulations, the provisions of the law, we have to first of all check professional competence of the judge. If we speak about qualification assessment, that is a more comprehensive examination of the candidate, and here we're talking about the professional and social competence, about professional ethics and integrity. I think that we should not make these two procedures equal, at least as for now. We need to finish qualification assessment of the people who have submitted applications following the rules we used to have, and we need to change the rules of judicial selection for trial courts in order to really simplify this procedure. If there is a question from the commissioners concerning this, I have my own vision of this. I think that it is a two-tier procedure. But if I answer your question, I should say that no, I don't think they should be made equal, as for now, at least not within the next 2 or 3 years. Okay, so let's continue with the topic of the qualification assessment and the details of qualification assessment and selection. There is well, not a very pleasant notion of academic lack of academic integrity, like plagiarism of research and scientific papers. People who present research papers may resort to plagiarism. I mean, they are not allowed, but they can do this, and they can also participate in the judicial selection procedures or be incumbent judges. What do you think? Is there any established fact of serious lack of academic integrity? Is it the ground for rejection? Is the ground for not accepting the candidate for the judicial position? And can this lack of academic integrity serve as the ground for the liability of the incumbent judge who has, suppose, written a PhD thesis over the recent 2 years, and this PhD thesis appeared to be plagiarism? What is your idea of this?
Дякую за запитання.
Thank you for the question. So let me start from the very beginning. Well, I do believe that lack of academic integrity that has been proven may be the ground for a person not completing their qualification assessment. Proven lack of academic integrity can be a ground for somebody not completing their qualification assessment. I don't really remember the second part of your question. I'm sorry. So the question was about some disciplinary charges. So let's say we have a judge, they perform their duties in a duly manner. There are no questions about any procedural terms, about their competence. So there are no questions about their professional competence, their professional activities as a judge. But it is discovered that their PhD thesis includes some plagiarized parts, and this fact has been proven. Do you believe that this is a sufficient enough ground for disciplinary charges, not for person not completing their qualification assessment, but charges against a person as somebody violating the procedure? Well, I don't really have an answer to this question, but I did think about it. The issue of plagiarism is widely discussed. But I cannot give you any specific answer as to why lack of academic integrity can be a ground for disciplinary charges imposed against a judge.
Добре, давайте перейдемо до дещо
Okay, let us move on to a simpler question.
ситуацію. Кандидат на посаду
Let's assume that a candidate judge,
що передує поданню ним
during a year prior to their application for the selection, has violated traffic regulations 30 times. So they violated the rules once per 10 days. So let's say this person violated the speeding regulations by 30 kilometers.
всі штрафи сплачені.
They paid all the fines.
Наразі, чи ви вважаєте, що
And do you believe that facts like these
проти доброчесності такої людини?
can be used as proof of lack of integrity? And can such systematic violations of traffic regulations become ground
Мови такому кандидату
for turning such a candidate down?
Так.
Yes.
Оскільки є системні
Yes, because we have the systemic nature of such violations. I understand your answer. So we are all people. We understand that there are no ideal criteria of integrity, and it's indeed difficult to find the limit of acceptable number of violations. Let's say up to 5 should be acceptable for a normal person. 30 violations, it's already a system. For me, 30 violations of traffic regulations means that a person is committing them in a systemic way, and they are not careful enough. Thank you. Thank you. That's all from my side.
Justice Vronska, my colleague, Judge Verlanov, opened up an area which I consider to be one of the most challenging areas that any society faces, and that is the pursuit of gender equality. I doubt that there is a more challenging question that any progressive and modern society faces, because it is certainly clear that women are in a disadvantageous position, and you pointed out some of the areas in which initiatives can be taken. Corporations, corporate governance, etc., greater involvement of women in politics, etc. I am from Canada. We have our own similar challenges with respect to the participation of women as judges on our courts. And it generally, I think, can be said that depending on the administration, we have between 30 and 40% of our courts staffed by women judges. A good illustration is our selection commission. We had 301 applicants for these 16 positions on the High Qualification Commission. Approximately only 1/3 of those applicants were women. And that may be in part attributable to the qualification in the law, which requires a minimum of 15 years experience. In many countries, you will be aware, there is a program called affirmative action that deals with a number of issues respecting minority participation in societal institutions. You advocate gender equality, and that is a very difficult concept to define. But I'm going to give you the opportunity to give us your definition. In the context of appointments to the High Qualification Commission of Judges of Ukraine, what do you consider to be an approach for gender equality, to achieve gender equality?
Забезпечення рівних прав.
Ensuring equal rights and opportunities, both to female and male applicants.
Але хочу зауважити,
But
що
I
я
only
розумію, не до вас.
want to note this. This is not a question to you. I understand that you were doing your best to keep the gender balance, but unfortunately, there are no women amongst the commissioners.
And do you think that is a disability?
I think so.
Я отримую.
Sure.
Well, I will not answer this question.
All right, let me move on to the business of the HQCJ. You will be well aware, I know, that the bulk of the work of the High Qualification Commission is the appointment of judges to the first instance courts and as well to the requalification of judges, the majority of which are also first instance courts. I ask this because you, of course, do not have experience working as a judge in the first instance courts. Your judicial career has been confined to the Supreme Court of Ukraine. What, in your experiences, would you bring our attention to in terms of your role and involvement in the work of the HQCJ and the first instance court evaluations?
Якщо ми говоримо про діяльність майбутньої вищої
If we are talking about the future HQCJ, it should be, first of all, mentioned
потенційним кандидатам бути готовим
that the potential candidates
напрямки роботи, які накопичилися 3 роки, вирішувати по черзі.
will not be able to go step by step in all the areas that have amassed over the past 3 years. We will have to do many things at the same time, including the selection of judges for the trial courts. But at the same time, we'll have to update and adjust our methodology of the assessment. And if we are talking about judges of trial courts, we need to calculate the workload to understand how many judges we still need.
Наскільки мені відомо,
At the moment, as far as I know, there is a methodology for calculating the workload developed with the help of USAID.
я вбачаю свою роль.
And I do believe that my potential role will lie in focusing on the adjusting of methodologies.
І ми досить
This has to do with the methodology of calculating the workload as well as the methodology of assessment.
процедуру
So
спрощення.
we need to be talking about the simplification of the procedure for the selection of trial court judges.
Я вбачала свою роль.
So I would see my role in working on the methodology.
That brings me, curiously enough, Judge Vronska, to my next question and last question. And you made the statement in our interview now with you that you feel that it's necessary to simplify the procedures of the HQCJ. There are those who advocate a more rigorous approach to the evaluation of judge candidates. That is to say, there should not be fewer processes, but in fact more intense processes, greater examination of information respecting judge candidates. How do you reconcile those two approaches? How can you simplify the approach on the one hand, and on the other hand, provide the important scrutiny that should take place with respect to judge candidates and their professional competence and integrity?
Дякую за запитання.
Thank you for this
Дякую
question.
за можливість пояснити свою
Thank you for the opportunity to explain my position. When I was talking about the simplification of the procedure for the selection of trial court judges, I was not talking about the simplification of the qualification assessment of the incumbent judges. When I was talking about the simplification of the procedure, I was talking about simplification of the stages. I was talking about shortened timelines. I'm not talking about less rigorous examination of the materials.
Я навпаки сказала
I,
з самого початку, чим
on the contrary, mentioned that the most scrupulous this examination is. So I would still distinguish between the procedure and other things. We need to review the procedure and simplify. But when we talk about the requirements, we cannot have lower level of requirements.
відбувається поверхнево.
Some people may have the concern that the selection is superficial. When I was talking about requirements, I used the word scrupulous. We cannot simplify the requirements. So when I was talking about the simplification, it was just about the stages of the selection.
Не треба їх поєднувати.
So we should not be reconciling the two. One does not exclude the other
Це навіть підсилює.
and practically reinforces the other, if I could say so.
Процедури добору
Shortening of the procedure when we are talking about the stages will give us an opportunity to focus more on scrupulous examination of the candidates meeting the criteria of professional competence and integrity.
Thank you for your answers. Stephen?
Can I, Judge, can I follow up my colleague's questions on the question of gender quotas? I think you said you favor gender quotas. I asked this question only because you understand the Ukrainian people better than we internationals do. We bring some expertise to bear, I hope, but on the other hand, you know the Ukrainian people and their character and their interests and their responses to things that we may be doing better than we do. We have tried to conduct a fair competition. As my colleague Judge Zarzhechny has indicated, about 1/3 of the people who are interviewing are women, but we haven't applied gender quotas in that process. Along with Judge Mizentsev, I spoke before the women lawyers a number of months ago, and I didn't hear any call there for gender quotas. But my question is this. I'm genuinely seeking your help and assistance. You do know the Ukrainian people better than we visiting members of the commission do. Will they look upon such quotas as enhancing their sense of trust in this process because we are affording more opportunities for women? Or will it diminish their trust in the process by a sense that the competition of the best is not being conducted as fairly as it should? That, in a nutshell, that in short, is really what the great debate in my home country has been about, which is why I think it's an important debate, as Judge Zarzhechny does, and why I ask you about this debate. It's been a very defining, controversial, divisive debate. Are we giving more opportunity, or are we depriving some of opportunity by gender quotas? Can I ask you one more time? I know it's been a difficult question for you, as it would be for anybody. But I ask you, what will be the sense of the Ukrainian people in the confidence and trust in our selection process and in the confidence and trust that the High Qualifications Commission will be something that will elevate the judiciary of your nation? Thank you.
Дякую за запитання. Дякую за
Thank you
увагу
for the
до
question.
питання гендерної рівності.
Thank you for paying your attention to the issues of gender equality. We've had similar discussions in Ukraine when we were introducing gender quotas during elections. And in my opinion, the society and the judiciary in general will only win from equal representation of men and women in the judiciary. At the moment, we don't have any public discussions. I don't know about any legislative initiative about the introduction of gender quota in the judiciary. That's why an attempt of the Commission to introduce gender quotas into the selection may be welcome. And as a supporter of gender equality, I cannot give you a different answer. I do believe that the perception of the society will be very much positive about the introduction of some gender quotas, even if they're not introduced on an official level.
Okay, well, thank you very much for clarifying that, Judge Vronska. Let us have our second round, and we'll begin with former prosecutor Burkhuizen.
I don't have any further questions.
Okay. Judge Mizensov.
Yes, I have. Зараз буде важке провокаційне питання.
I'm going to ask you a difficult, provocative question.
На тему гендерної рівності.
Dear Anna, let's follow up on the issues of gender equality.
Процедурне,
So there is a certain procedure
до якої
according to which our commission must recommend at least 32 people to be appointed as members of HQCJ for the consideration of High Council of Justice. And the High Council of Justice, because of the specifics of this competition taking place under such circumstances, will have to use two quotas, one for judges and the other for non-judges, lawyers. So you are part of the judges quota.
конкуренція буде
And
відбуватися у кожній з
the
цих
competition will take place in between judges and between lawyers.
гендерної рівності
So, in your opinion, the issue of gender equality,
вибору для Вищої ради правосуддя
taking into account the difficult decisions that the High Council of Justice will have to make to select 16 members out of 32, and also they will have to remember about 8 of them being judges and 8 of them being lawyers. Does the High Council of Judges need to consider the principles of gender equality in this selection? Until we have some legislative provisions about gender equality for HQCJ members, other than complying with the criteria of professional competence and integrity, that's up for the Commission to decide. And the society and the civil society will see the results in a more positive way if the principles of gender equality is observed. Thank you. That's clear.
Justice Vronska, I want to thank you for opening the discussion on gender equality with respect to the process, not just of our selection commission, but as well in due course with the process to be followed by the High Qualification Commission for judges. I am very encouraged by your advice to us that if appointed, you will be an advocate for increased participation by women in not just the selection of judges, but as well the holding of judicial office. So again, I think your answers and your introduction of this whole area has been very informative for our commission members, and I thank you for it. I apologize for not asking you a question But I think we've had a very fulsome discussion, and I wanted you to know that we appreciate the importance of this issue that you have raised. Thank you,
Judge Volk,
Stephen.
Judge Vronska, we have tried to allow our candidates to have the final word, and we would like to afford you that same opportunity, and we'd like to give you as much as 3 minutes or 180 seconds to say anything that you would like to that you think it requires clarification or elaboration. Please.
Well, first of all, I would like to thank the Selection Commission for the transparent conditions of the competition, for at least your striving to observe the principle of gender equality. I would like to thank the armed forces of Ukraine for the opportunity to participate in this competition and to answer your questions while staying at my workplace in Kyiv. So in summary, I would like to tell you that when assessing both candidate judges and when conducting qualification assessment of incumbent judges, we should be paying attention first to the independence of a judge. And I'm not talking about political neutrality or dependence of a person on a group of people or an individual or a politician, but I'm talking about inner independence, the ability of a person to make the decisions in compliance with their conviction, regardless of the outside circumstances, because I do believe that the independence of the judiciary in Ukraine is insufficient, and many people know that. I think that the general independence of the judiciary is the sum total of the independence of all the judges that make up the judiciary. I think that we should be paying attention to this criteria as well. Thank you for your attention.
Well, thank you very much, Judge Vronska. We appreciate all that you've done this afternoon, and it's been great to have you here. Thank you.
Yes, Justice Vronska, this ends our interview of yourself as a candidate. We thank you for your participation, and we will now sign off. Have a good day.
Thank you.